This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about litigation and why a plaintiff should never hide an issue until the date of trial, because an insurer is entitled to notice of reformation before the trial begins. At trial on the breach of contract action, the plaintiff sought to amend their complaint to include an otherwise untimely reformation claim based on mutual mistake and a preexisting oral agreement. In 34-0673 LLC et al. Versus Seneca Insurance Company, an October 27, 22 decision of the New York Court of Appeals, the insurer appealed the reformation of its policy sought for the first time at trial. Seneca issued plaintiffs a multi-million-dollar written insurance policy covering several of plaintiffs' vacant commercial properties. The parties did not dispute the contents of the policy, only whether plaintiff's complaint asserting breach of contract and seeking damages put the defendant insurance company on notice of the transactions or occurrences underlying the plaintiff's belated claim to reform the policy to eliminate the condition that supported the claim denial. The policy as issued included a Protective Safeguards Endorsement, a PSE, that required the plaintiffs, among other things, to maintain an automatic sprinkler device on the subject property as a material condition precedent to coverage. Approximately 1 month after the policy went into effect, the insurance company's agent conducted an inspection of the premises and issued a report to the plaintiff's principal and sole owner, Mohammed Malik, advising him that there was no compliant sprinkler system on the premises and recommending that the plaintiffs notify the insurer defendant of the system's non-operability. Malik did not do as advised. A little more than 4 months later, there was a fire on the premises, and plaintiffs requested payment under the policy for damages incurred. Defendant notified the plaintiff it was denying the claim under the PSE because the plaintiffs did not maintain a working sprinkler system. Plaintiffs sued for breach of contract, seeking over $2.4 million in damages based on the defendant's failure to cover the fire loss. At trial, for the first time, plaintiffs argued that the written policy did not reflect the parties' agreement. Malik testified that he told his insurance broker he did not want the policy to include a Protective Safeguards Endorsement because the properties were vacant buildings or lots and most did not have sprinklers. However, he admitted that he did not read the insurance policy, a sin of the first order with regard to any insurance litigation. Defendant's vice president of underwriting, Carol Mueller, testified that an underwriting file disclosed during discovery did not contain documents referencing the PSE or the sprinkler system, that the premiums quoted for the policy were for a non-sprinkled building, and that the inclusion of the PSE may have been a mistake. After plaintiff rested, they orally moved to amend the complaint to conform the pleadings to the proof by adding a claim for reformation. The court granted plaintiff's motion, concluding that the claim related back to the complaint because it was part of the whole thrust of the complaint originally, and the jury should decide whether the PSE's inclusion resulted from a mutual mistake. The jury returned a verdict in favor of the plaintiffs on the reformation claim, finding the plaintiffs established by clear and convincing evidence that the parties' true agreement was a policy without a PSE, and it was a mutual mistake to include the PSE in the policy. The defendant insurer maintained that the complaint alleged only non-performance and contained no indication that the contract failed to reflect the parties' intent. Defendant also asserted surprise and prejudice because it couldn't defend or even do any discovery on the issue. Regardless, the appellate division affirmed the judgment in the plaintiff's favor, holding that the court providentially granted plaintiff's application to conform the pleadings to the trial evidence to assert a claim for reformation. Now, the Court of Appeal, the highest court in the state of New York, found that applications to amend pleadings are within the sound discretion of the court, and exercise of such discretion may be upset by an appellate court only for abuse as a matter of law. However, the High Court concluded there was no sound basis in law to grant the amendment and to add an untimely claim. It was undisputed that when plaintiffs sought to amend their complaint, the statute of limitations on the reformation claim had expired and was therefore time-barred unless it related back to the original pleading. Plaintiff's reformation claim would only relate back to the original complaint and is thus not barred by the statute of limitations only if the complaint placed the defendant on notice of the transactions, occurrences, or series of transactions or occurrences to be proved in support of the claim. To plead reformation, a plaintiff must allege sufficient facts supporting a claim of mutual mistake, meaning that the parties have reached an oral agreement and, unknown to either, the signed writing does not express that agreement. New York recognizes that there is a heavy presumption that a deliberately prepared and executed written instrument manifests the true intention of the parties, and the proponent of reformation must show in no uncertain terms not only that mistake or fraud exists, but exactly what was agreed upon between the parties. In plaintiff's complaint, they failed to give notice to the defendant of the transactions or occurrences on which plaintiffs based their reformation claim. In their original complaint, plaintiffs reference a specific written policy which they identified as the parties' agreement and which they alleged defendant breached. The complaint further alleged that the plaintiffs complied with all of the conditions precedent and subsequent pursuant to the terms of the subject policy. The latter allegation was fatal to plaintiff's assertion that the complaint provides notice of the transactions or occurrences to be proved in support of a reformation claim. In fact, if anything, it suggests the opposite, because by asserting total compliance with the policy as issued and its conditions, plaintiffs necessarily disclaimed any challenge to the policy's terms, specifically the PSE. The reformation claim, as advanced by plaintiffs, was based on a purported oral agreement negotiated by Malik with his broker that preceded the contract's formation, whereas the breach of contract claim in the original complaint was based on the written policy which includes the PSE and with which plaintiffs alleged full compliance. Therefore, nothing in the standalone breach of contract claim put defendant on notice that there was a prior oral agreement that excluded the PSE and that the PSE's inclusion in the written policy was a mistake. Plaintiff's complaint foreclosed a factual or inferential basis for notice of mutual mistake, notice by unqualifiedly alleging that they complied with all of the conditions precedent and subsequent pursuant to the terms of the subject policy. The complaint contained no alternate theory of recovery or factual allegations based on pre-formation transactions or occurrences. The complaint, therefore, only put the defendant on notice of transactions or occurrences related solely to the written policy and plaintiff's total compliance with that agreement terms, which include the PSE's sprinkler requirement. As a result, The Reformation claim cannot relate back to the plaintiff's original pleading because it only alleged compliance with the policy as written, and the trial court abused its discretion as a matter of law when it granted plaintiff's motion to amend to include the time-barred claim. Plaintiff's motion to amend the complaint to include a Reformation cause of action was denied, and the case was remitted to the Supreme Court, the trial court, of New York County for entry of judgment in accordance with the opinion, so that the insurer owed nothing. In my opinion, the plaintiff insured and counsel made a decision at the time the suit was filed to sue only for breach of contract and bad faith, although the plaintiff knew he felt the policy issued was not that he ordered, and when he was told of the error before the fire, did nothing to correct the terms and conditions of the policy. Rather than dispute the PSE as an error, he sued claiming he had complied with the condition that he was advised did not exist. Only later, during trial, did he seek reformation because, of course, there were no PSEs on his property. The trial court erred, allowing reformation because the defendant was not given notice of the equitable claim and was sandbagged and unable to do discovery or bring in evidence to counter the claim. Malik's failure to react to the advice about the condition requiring a PSE and that he lacked an appropriate PSE defeated his claim. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the link zalma.com/blog. You can also subscribe to the blog and will receive notice of every new blog post, which is usually once every 5 days, Monday through Friday. You can also subscribe to my Rumble channel and my YouTube channel so you can see these videos, which are also available free and which you should subscribe to. And I'd appreciate it if you click on the like button and or the Rumble button when you do. If you found this video to be of interest or useful to you, please tell your colleagues and friends so that they can also subscribe to the blog and to the videos. Thank you for your attention.